Our next guest is Will Haddad of Beck, and Riden. Is that correct?
Riden. Yeah, two-thirds of it. Yep.
Oh, well. Sorry, Mr. Riden.
You wouldn't mind.
I'm glad you didn't bring him.
You wouldn't mind.
That's okay. Will, why don't you tell us about your practice?
Sure. My practice is broadly categorized as business litigation. So I handle everything from trade secret and non-compete cases to closely held company disputes to even some white-collar defense, principally defending against SEC enforcement actions. Our firm does business litigation and employment litigation. And the firm is 4.5 years old, former big firm lawyers, and we're enjoying what we do and enjoying serving our clients.
Why Beck Reed? Because what's interesting, we had talked about it before in the show. You come from a bigger firm background from Hinckley, then you went to a real specialty litigation firm at Calora, and now Beck Reed, and obviously somebody like yourself who really has a strong litigation background picked that firm for a reason.
Yeah, it was in part a personal connection from a former colleague of mine who knew Russell Beck, one of the founders of my current firm, put us in touch. I like the entrepreneurial bent of the firm. I like the growth trajectory of the firm. And basically, I really like the people. We have a wide bandwidth of cases we can take on. And there was an established client base, including corporate clients, when I moved over. So there was stability and an upward trajectory that really interested me. And since then, it's been a great fit.
Excellent. Now you talk about your SEC practice. How did you get involved in that, and can you tell us some of the work you've done in that?
Absolutely. Great question. Thank you. So I began my practice at Sherman and Sterling in New York.
Wow.
These were the days of Elliott Spitzer and of Department of Justice investigations into Wall Street. And so naturally, as a starting out associate, I did what I was told, and the cases were principally SEC defense, accounting fraud, public company fraud, pump and dump stock cases, things like that. And so I gained that experience with internal investigations, but also class action litigation defense.
Interesting.
And so I continued some of that at Hinckley and also at Calora. And I've continued that practice mainly in the representation of individuals who are indemnified by a company, who are under investigation, or maybe a witness in a state regulatory, Mass Securities Division, Secretary Galvin type case, SEC case, or in limited instances, a criminal case.
Mark said about before litigation, but there is a sort of in-between zone where people are creating the problem, living the problem, acknowledging the problem, where they're not dealing with it, where they don't have to necessarily go to litigation. I'm assuming you would prefer that families don't head into litigation, that's the last resort of a broken down family that hasn't dealt with years of decay, we'll call it that.
Absolutely. And it's contrary to a lawyer's trying to get rich interest, but that's not the duty of a lawyer. The duty of a lawyer is to act in the best interest of the client,
right,
as efficiently as possible, and to try to be creative about how you stage the mediation process, who's involved, what's involved, thinking about assets that aren't necessarily monetary. Something as seemingly petty as you can't go here on vacation,
right,
for that period because we want to have separation of the families. That's not monetary. But those things can be brought in to piece together a mosaic that might get it done.
I know you do some work with non-compete litigation, and what's interesting is, and Jeffrey and I have talked about this, is Massachusetts is one of those that still enforces non-competes, but then you have obviously California that doesn't, and in the world of startups, that's very key.
Absolutely. There have been studies done about whether our competitiveness compared to California relates to this. I think it's an oversimplification. Massachusetts is sort of in the middle. You have states like Florida, which presumptively enforce up to 2 years, and a non-solicit in a year on a non-compete. Massachusetts is a sort of case-by-case assessment. You have to have a legitimate business interest involved, like trade secrets or goodwill, and then there has to be an enforceable non-compete. Judges will write them down to make them more reasonable, but they'll look at the facts of every case.